Good morning, everyone, and we are on our new time slot or day of release, which is on a Wednesday and at 11 o'clock in the morning, unless we are facing with some technical difficulties. Now, for today, our topic would be on mediation rules. Now, our focus for today's lesson would be Republic Act 9285. And this act was enacted in April 2004. And this is known as the Alternative Dispute Resolution or ADR Act of 2004. And mediation, to remember, mediation is just one of the topics or alternate methods of alternative dispute resolution mentioned and covered by the Act. So it is the policy of the state that ADR or Alternative Dispute Resolution as an efficient tool and alternative procedure for the resolution of appropriate cases. So appropriate cases must be emphasized given that mediation and other ADR methods or mechanism do not apply to all cases. And ADR also is a means to achieve speedy and impartial justice and also a way to declog court dockets. Now, what is mediation? It is a voluntary process according to RA 9285 in which a mediator selected by the disputing parties. So here the element of consent of the parties involved facilitates communication and negotiation and assists the parties in reaching a voluntary agreement. So again, the element of consent is applicable from the beginning up to the end or when there is a voluntary agreement reached. And a mediator is a person who conducts the mediation. Now, a mediation party is a person who participates in a mediation and whose consent is necessary to resolve the dispute. So, aside from consent as an element, there is an adverse party, or as we say, there is an adversarial case. So there is a cause of action against another person, and there is a remedy after that cause of action is being established. Now, a mediator, again, is the one who conducts the mediation. Now, what is important also is that during the mediation proceedings, there is what we call as a record, an information written on a tangible medium or stored in an electronic or other similar medium or retrievable form. So, before we go to the core of mediation as a proceeding in resolving disputes, we have to know the exception. It does not apply to labor disputes according to the Labor Code of the Philippines or Presidential Decree number 442 or the civil status of persons. It does not apply. Also on the validity of marriage, because the policy of the state that it is only the courts that have the power to determine the validity or invalidity of a marriage. And also it does not apply to legal separation. And another set of cases in which mediation does not apply is when it comes to jurisdiction of courts, because BP 129 or the Judiciary Reorganization Act determines and establishes the jurisdiction of the court, and also future legitim. And we have to emphasize that future legitim because existing legitims may be subject of a waiver and also can be mediated. What about criminal liability? It cannot be subject of mediation because it is the revised penal code or special penal laws that determine the criminal liability of the person, and it cannot be subjected to consent or the voluntary agreement of parties. Now, or any other aspects of law that could not be compromised. So you have to take note of the exception of mediation. Now, in the next part of the lesson, we will be tackling the core or the provisions under RA 9285 that deal with mediation per se. And before I end this lesson, again, we encourage you to like our Facebook channel or our Facebook page, and you can also go to our YouTube channel and also our website. In this way, you can have better navigation experience, and the videos there are grouped according to the bar subjects. Thank you so much for listening, and I hope to see you in the next video lesson. Take care and have a good day.